White House is after him. The New York Times is after him. Senate and House Democrats are after him. They're all calling on him to step down.
Prosecutor Starr was in New Orleans as lead defense counsel to the tobacco industry in a landmark class action suit.
I'm on my way back to Little Rock right now.
On that very day in Little Rock, David Hale, Starr's most important witness in his work.
Kenneth Starr, the White House counsel who represented Big Tobacco in the New Orleans case, said the decision, quote, vindicates fully the industry's position that a class action is entirely inappropriate as a method for testing these novel claims. Philip Moore...
We will be watching Wall Street tomorrow when it opens. It appears many average investors are, as Rick suggested, sitting tight during this rocky ride on the stock market. Terry Okita shows us how some are handling today's drastic drop.
Dow Jones, S&P 500, NASDAQ, Amex.
29-year-old Gary Partoyan has been keeping close watch on his stocks. Monday's 512-point plummet was no surprise.
I'm nervous, I'm anxious, but I'm not panicking.
Partoyan's two big stocks, Dell and Microsoft, have taken a beating, but he says he's leaving his investments alone.
They've dropped, I don't know, probably 25% in the last month or so. But they're actually doing better than some of the other stocks I've got. If I sell now, I take the loss. If I hold, I could conceivably get my gains back.
What Partoyan won't do right now is buy stocks, not until he's sure the market has bottomed out. That's where investor Paul Taylor differs. The 28-year-old says he will buy while stocks are lower and, like Partoyan, hold on to what he already has.
When the Black Monday hit in '87, my dad sold most of his stocks, and he's regretted it ever since. So today I try to learn a lesson from that.
Taylor's taking the Dow's drastic drop in stride. He's not nervous, and he's definitely not panicking.
I think provided you take the long-term view, there really hasn't been any substantial risk demonstrated in keeping your money in the stock market. In fact, it's probably the highest yield investment you can get over time.
Both men say they're in it for the long haul. They're just hoping they're not behind the 8-ball when the time is right to buy and sell. In McLean, Terry Okita, Channel 9 Eyewitness News Tonight.
At 11:13, we'll take a look at some big local stocks and how they're doing.
Now, the House Judiciary Subcommittee on the Constitution looks at lawsuits filed over accessibility standards in the 1990 Americans with Disabilities Act. Witnesses include actor Clint Eastwood, who owns a hotel that's been sued under the act. Florida Republican Charles Kennedy chairs the panel. It's about 2.5 hours.
The subcommittee will be in order. There's widespread agreement that the Americans with Disabilities Act furthers the admirable goal of providing a more accessible environment for the disabled, and that since its passage a decade ago, the ADA has done much to make public accommodations more accessible to everyone. The subcommittee is conducting this hearing today because of concerns that the progress brought about by the ADA is being threatened by a growing number of lawyers who are generating large sums in legal fees for pointing out often simple fixes that would bring properties into compliance with the ADA. The lure of large attorneys' fees is so great that attorneys may even settle cases for attractive sums for themselves by agreeing to terms by which a property would not even be fully accessible under the requirements of the ADA. This sort of litigation abuse stems from the simple fact that the ADA does not contain a simple notice provision. This gap in the law now poses a danger that attorneys will continue to exploit it and needlessly foment ill will between the disabled community and small property owners who would, in good faith, bring properties into compliance with the ADA if only they were alerted to the law's specific requirements. H.R. 3590, the bill we consider today, represents an attempt to ensure that businesses will not only be put on notice of their obligations under the ADA, but they will also have the funds available to remedy any violations of the ADA and keep their businesses running for both the disabled and the non-disabled. Giving advance notice of potential ADA violations in advance of bringing a lawsuit is simply good practice among lawyers, and no doubt the majority of lawyers give such advance notice. Unfortunately, however, it appears that some lawyers will not conduct themselves in accordance with good practice unless good practice is codified in the law. That is what the ADA Notification Act would do. Of course, some businesses may continue to ignore or refuse to fulfill their duties under the ADA to make their properties accessible to the disabled. Under H.R. 3590, such businesses will remain subject to suit under all the provisions of the ADA, as they have been since it was enacted. However, it is hard to see why those business owners who readily meet their obligations under the ADA when put on notice of those obligations should have to hand over large amounts of money to attorneys. I want to thank my colleagues from Florida, Mr. Foley and Mr. Shaw, for their leadership on this legislation. I'm very grateful to both of you, Mr. Foley and Mr. Shaw, for bringing this important issue to the attention of the Constitution Subcommittee and the Judiciary Committee. I look forward to hearing your testimony as well as the testimony of all the other witnesses who will appear at today's hearing. Now, I would now like to recognize Mr. Watt for 5 minutes.
Thank you, Mr. Chairman, and I thank the chairman for convening a hearing about this.
Committees on Capitol Hill. What they're going to do now is begin general debate on the bill H.R. 2372, named the Private Property Rights Implementation Act. This is live coverage.
Simplify and expedite access to the federal courts for injured parties whose rights and privileges secured by the United States Constitution have been deprived by final actions of federal agencies or other government officials or entities acting under color of state law, to prevent federal courts from abstaining from exercising federal jurisdiction in actions where no state law claim is alleged, to permit certification of unsettled state law questions that are essential to resolving federal claims arising under the Constitution, and to clarify when government action is sufficiently final to ripen certain federal claims arising under the Constitution.
Pursuant to the rule, the bill is considered read the first time. The gentleman from Florida, Mr. Kennedy, and the gentleman from North Carolina, Mr. Watt, each will control 30 minutes, and the chair would recognize the gentleman from Florida.
Thank you, Mr. Chairman. I would now yield to myself such time as I may consume. Members of the House, the Private Property Rights Implementation Act of 2000, which is now under consideration by the House, would provide property owners with meaningful access to justice when they seek to assert their federal rights under the Takings Clause of the Fifth Amendment in federal court. The Fifth Amendment to the United States Constitution prohibits the federal government from taking private property for public use without just compensation. This Takings Clause, which was made applicable to the states through the 14th Amendment, has been held to require the government to provide just compensation not only when property is directly appropriated by the government, but also when governmental regulations deprive a property owner of all beneficial uses of the land. Under current law, however, property owners whose property has been taken through government regulation may not proceed directly to federal court to vindicate their rights. Instead, they must first clear two so-called prudential legal hurdles designed by the Supreme Court to help ensure that such claims are sufficiently ripe for adjudication. First, property owners must demonstrate that the government entity charged with implementing the regulations has reached a final decision regarding the application of the regulations to the property at issue. And second, property owners must show that they sought compensation through the procedures the state has provided for doing so. The application of these requirements by the lower federal courts has wreaked havoc upon property owners whose taking claims are systematically prevented from being heard on the merits in federal court. Under these requirements, many property owners are forced to endure years of lengthy, expensive, and unnecessarily duplicative litigation in state and federal court in order to vindicate their constitutional rights. In today's debate, we will hear accounts of the Kafkaesque legal maze that property owners are thrown into. And I would urge the members of the House to pay close attention to the experiences that Americans are going through under these faulty legal rules that are now being applied by the courts.
Property owners whose federal takings claims are dismissed on ripeness grounds by federal courts also sometimes face a procedural pitfall that results from being forced to litigate first in state court. Application of the doctrines of res judicata and collateral estoppel to bar federal takings claims. This procedural trap operates as follows. Federal court will dismiss a property owner's takings claim because the property owner has not first litigated the claim in state court. When the property owner returns to federal court after litigating the state law claim in state court, the federal court will hold that the federal takings claim is barred because it could have been litigated in the state court proceedings. The effect of the reasoning of these cases is that many property owners have no opportunity to have their federal constitutional claims heard in federal court. No other constitutional rights are subjected to such tortuous procedural requirements before the merits of the plaintiff's claims can be heard. In addition to these procedural hurdles, federal courts have also invoked various abstention doctrines in order to avoid deciding the merits of takings claims that are brought to federal court. The combined effect of all these procedural rules is that it is exceedingly difficult for property owners to vindicate their constitutional rights in federal court. According to one commentator, federal courts avoided the merits of over 94% of all takings cases litigated between 1983 and 1988. Another more recent study found that in 83% of the reported cases raised in federal court between 1990 and 1998, that 83% of those were dismissed on ripeness or abstention grounds at the district court level. H.R. 2372 was designed to address the systematic suppression of property rights claims by clarifying and simplifying the procedures which govern property rights claims in federal court. In particular, H.R. 2372 clarifies for purposes of the application of the ripeness doctrine when a final decision has been made by the government regarding the permissible uses of property. H.R. 2372 also removes the requirement that property owners litigate their takings claims in state court first and prevents federal judges from abstaining in cases that involve only federal takings claims. Under the bill, before a landowner can go to federal court, the landowner who has received a denial from a local government must pursue a wide range of available options at the local level. And this is a very important provision of the bill, and I urge all the members of the House to pay close attention to this provision of the bill in particular. The claim has been made that this bill short-circuits the zoning process, that somehow we run an in-run around the zoning process, we eliminate any incentive for aggrieved property owners to negotiate with the local governments who are involved in the zoning. Those claims are simply untrue. Under the bill, the landowner must pursue an appeal to the local planning commission, seek a waiver from the local zoning board, and seek review by elected officials if such redress is available under the local procedures. Where the government disapproves an application and explains in writing the use, density, and intensity of development that would be approved, the bill requires that the landowner submit a second application and be rejected a second time before going to federal court. So this bill shows substantial deference to the local zoning procedures. But the bill does recognize that at the end of the process at the local level, when all these steps have been gone through, if the local government makes a decision that results in the taking of property without compensation, there should be access to the federal courts to vindicate the constitutional right which has been violated. Now, under the bill, for a case to be ripe for adjudication in federal court, the government must either actually reach a final decision on the application, or else the locality or federal government must fail to act on the application within a reasonable time. The constitutional basis for this legislation is found in Congress's well-established authority to regulate practice and procedure in the federal courts. The ripeness requirements that the courts have imposed are not mandated by the Constitution. There'll be some debate over that here today. It's clear that there are some problems with the decisions of the Supreme Court with respect to ripeness. Otherwise, we would not be here on the floor with this bill in an effort to correct those problems. But the Supreme Court, in recent cases, has made clear, the Supreme Court has stated, that the requirements with respect to ripeness that are at issue here are prudential, what the court calls prudential procedural requirements that are created by the court and are not constitutional requirements. Unfortunately, what the courts have considered prudential requirements are in fact working a grave injustice and denying Americans who have suffered a constitutional deprivation meaningful access to federal courts. The bill before the House today represents an appropriate exercise of Congress's authority over procedure in federal courts to ensure that property rights are no longer treated as second-class rights with no meaningful federal forum for their vindication. I urge the members to vote in favor of H.R. 1218, to reject the weakening amendments that will be offered, and to have the House move forward with this important legislation to protect constitutional rights. And with that, Mr. Speaker, I would reserve the balance of my time.
Gentleman reserves his time. The gentleman from North Carolina.
Thank you, Mr. Chairman. I yield myself as much time as I may consume.
Gentleman's recognized.
Thank you, Mr. Chairman. May I inquire of the chair concerning the amount of time remaining on both sides?
The gentleman has 22 minutes remaining, and the gentleman from North Carolina has 21 minutes remaining.
I thank you, Mr. Chairman. I would now yield to the gentleman from California, Mr. Miller, 5 minutes.
Gentleman from California for 5 minutes.
Thank you, Mr. Speaker. The argument made by my distinguished colleague was eloquent. However, it has nothing to do...
The subcommittee will be in order, and it's probably going to be necessary for the staff to close the doors, otherwise we'll have noise from the hallway. In recent years, with the growth of the Internet, the FBI has encountered an increasing number of criminal investigations in which criminal subjects have used the Internet to communicate with each other or their victims. Because the FBI believes many Internet service providers lack the ability to discriminate between communications in order to isolate the specific types of information that may be authorized to be gathered under a court order, the FBI has designed and developed a program called Carnivore, which enables the FBI to isolate, intercept, and collect communications that are the subject of lawful orders. The first news of Carnivore came in April during testimony before the Subcommittee on the Constitution by attorney Robert Korn Revere, who represented an Internet service provider that tried to resist attaching the Carnivore program to its network. It has also been reported that one of the nation's largest Internet service providers, Earthlink Inc., has refused to install Carnivore on its network because attaching the program in the past caused its remote access servers to crash, eliminating service to customers. Other ISPs have stated publicly that they would challenge an order to attach Carnivore to their networks. While these industry officials have expressed willingness to cooperate with law enforcement to comply with legitimate court orders, they are concerned about the effects attaching Carnivore to their networks will have on the security of their infrastructure and the privacy of their customers. At a press conference on July 12, Attorney General Reno stated that she does not want Carnivore, quote, to be a tool that is in any way a cause of concern for privacy interests, close quote. Today's hearing provides federal law enforcement the opportunity to address the the privacy concerns that have been raised. More broadly, Carnivore raises the question as to whether existing statutes protecting citizens from unreasonable searches and seizures under the Fourth Amendment appropriately balance the concern of law enforcement and privacy. Law enforcement is concerned that the information needed to keep the public safe remains available. Individual citizens are concerned that a sufficient degree of privacy and the integrity of personal information be maintained in an age of modern communications and information storage, where information that may have traditionally been kept in a file cabinet at home is now electronically stored by a third party in cyberspace. The hearing today will also address this balance of interests. As we consider the use of Carnivore, it is important that our deliberations be based on facts and not on unsupported suspicions and irrational fears. At the same time, we should be sensitive to any potential for abuse of the Carnivore system. Even a system designed with the best of intentions to legally carry out essential law enforcement functions may be a cause for concern if its use is not properly monitored. I look forward to hearing from all of our witnesses today, and I now recognize Mr. Watt.
Thank you, Mr. Chairman. I confess that up until about 10 days to 2 weeks ago, I had paid very little attention to this whole Carnivore project, and at about that point, I started to get inquiring telephone calls from the media and press about what I knew about Carnivore. I don't know much more about it today, and that's why I want to start by praising the chair of the subcommittee for convening this hearing, because I agree with the chair that whatever information we have and however we proceed as a committee and as a Congress needs to be based on the facts.
Quite a few peace groups here. An electoral system in which all Americans are able to register as voters, remain on the rolls once registered, and vote free from harassment. Mr. Speaker, our democracy begins and ends with the fundamental right to vote. Congress must act immediately to ensure that every American has the right to vote and to have their votes counted. Time is running out for the 107th Congress. We've come so close to the compromise, and the price for not passing election reform is far too high. It is imperative that the conference committee finish their hard work and come to an agreement before October the 1st, because we cannot afford to let this opportunity slip away. I thank you, and I reserve the balance of my time.
And coming up today on the House floor, next, debate on limiting medical malpractice lawsuits awards. Later on, debate on the Department of Justice Appropriations Authorization Act, the conference report on that. And later, possible consideration of a continuing resolution for fiscal year 2003. The last vote expected this evening between 5 and 6.
For what purpose does the gentleman from Wisconsin rise?
Speaker, pursuant to House Resolution 553, I call up the bill H.R. 4600 and ask for its immediate consideration.
The clerk will report the title of the bill.
H.R. 4600, a bill to improve patient access to health care services and provide improved medical care by reducing the excessive burden the liability system places on the health care delivery system.
Pursuant to House Resolution 553, the bill is considered read for amendment. In lieu of the amendments recommended by the Committees on the Judiciary and Energy and Commerce, the amendment in the nature of a substitute printed in the House Report 107-697 is adopted. The gentleman from Wisconsin, Mr. Sensenbrenner, and the gentleman from Michigan, Mr. Conyers, each will control 20 minutes. And the gentleman from Pennsylvania, Mr. Greenwood, and the gentleman from Ohio, Mr. Brown, each will control 10 minutes. House will be in order. Chair recognizes the gentleman from Wisconsin, Mr. Sensenbrenner.
Speaker, I ask unanimous consent that all members may have 5 legislative days within which to revise and extend their remarks and to include extraneous material on the bill H.R. 4600 currently under consideration.
Without objection, so ordered.
Speaker, I yield myself such time as I may consume.
Gentleman's right. Gentlemen, suspend for 1 minute. All members, please take seats and cease audible conversation. Gentleman's recognized.
Mr. Speaker, a national insurance crisis is ruining the nation's essential health care system. Medical professional liability insurance rates have soared, causing many insurers to either drop coverage or raise premiums to unaffordable levels. Doctors and other health care providers are being forced to abandon patients and practices, particularly in high-risk specialties such as emergency medicine and obstetrics and gynecology. This trend has had a particularly negative impact upon women, low-income neighborhoods, and rural areas, and in medical schools large and small. When California faced a similar crisis over 25 years ago, Democratic Governor Jerry Brown, following the recommendation of the gentleman from California, Mr. Waxman, then the chairman of the California Assembly's Select Committee on Medical Malpractice, enacted the Medical Injury Compensation Reform Act, known as MICRA. MICRA's reforms include a $250,000 cap on non-economic damages, limits on contingency fees lawyers can charge, and provisions that prevent double recoveries. According to the Los Angeles Times, quote, because of the 1975 tort reform, doctors in California are largely unaffected by increasing insurance rates. But the situation is dire in other states. Exhaustive research by 2 Stanford University economists has confirmed that direct medical care litigation reforms, including caps on non-economic damage awards, generally reduce malpractice claims rates, insurance premiums, and other stresses upon doctors that may impair the quality of medical care. The Health Act includes MICRA's reforms, while also creating a fair share rule by which defendants are only liable for the percentage of damages for which they are at fault. Additionally, H.R. 4600 sets reasonable guidelines but not caps on punitive damage awards. Under this legislation, a punitive damage award cannot exceed the greater of $250,000 or 2 times the amount of economic damages that are awarded. The Health Act will accomplish reform without limiting compensation for 100%. That's 100%, or all of the plaintiff's economic losses, meaning any loss which can be quantified and to which a receipt can be attached. These include their medical costs, lost wages, future lost wages, rehabilitation costs, and any other economic out-of-pocket loss suffered as a result of a health care injury. Additionally, although this legislation places a cap on non-economic damages, it also allows deserving victims to keep more of their jury awards by limiting the percentage that lawyers can take. This is accomplished according to a sliding scale that caps legal fees down to 15% of awards exceeding $600,000. Without such reforms, lawyers can take their standard 1/3 to 40% cut from whatever victims recover. Enactment of this bill will allow victims to keep roughly 75% of awards under $600,000 and 85% of awards over that amount. Under the Health Act, the larger the demonstrable real-life economic damages are, the more the victims will get to keep. A recent survey conducted for the bipartisan legal reform organization Common Good whose board of advisors includes former Clinton administration Deputy Attorney General Eric Holder and former Democratic Senator Paul Simon of Illinois, reveals the dire need for regulating the current medical tort system in America. According to the survey, which was conducted by the reputable Harris Organization, first, more than 3/4 of physicians feel a concern about malpractice litigation has hurt their ability to provide quality care in recent years. Second, 79% of physicians report that fear of malpractice claims causes them to order more tests than they would based only on the professional judgment of what is medically needed. As former Democrat Senator and presidential candidate George McGovern and former Republican Senator Alan Simpson have written, legal fear drives doctors to prescribe medications and order tests, even invasive procedures that they feel are unnecessary. Reputable studies estimate that this defensive medicine squanders $50 billion a year. The Common Good Survey also asked physicians the following question. Generally speaking, how much do you think that fear of liability discourages medical professionals from openly discussing and thinking of ways to reduce medical errors? An astonishing 59% of physicians replied, a lot. Americans want to see their friends and loved ones receive the best and most accessible health care available. But with greater and greater frequency, doctors are not there to deliver it because they've been priced out of the healing profession by unaffordable professional liability insurance rates. Sound policy does not favor supporting one person's abstract ability to sue a doctor for unlimited and unquantifiable damages when doing so means that health care will become less accessible and less affordable to all Americans, particularly to women, to the poor, and to those who live in rural areas. The American Bar Association estimates that there are 1 million lawyers in the United States. But all of us, all 287 million Americans are patients. And as patients and for patients, I urge my colleagues to support the Health Act and reserve the balance of my time. To recommit will accomplish should it pass. I yield the balance of my time to the gentleman from Pennsylvania, Mr. Greenwood.
Gentleman must remain on his feet.
Texas rise.
Mr. Chairman, I rise in opposition to the
Gentleman is
amendment.
recognized for 20 minutes.
Thank you, Chairman. Mr. Chairman, I yield at this time 3 minutes to the gentleman from Iowa, the distinguished chairman of the Budget Committee, Mr. Nussel.
Chairman is recognized for 3 minutes.
First, I want to thank the distinguished majority leader for his fine work on this piece of legislation. Congratulate him on it. Well, we've got a good bill here, folks, and we're about to just blow a hole so wide in the budget you ain't seen nothing. In fact, we asked CBO to score, the Congressional Budget Office, to score this amendment because we wanted to at least be able to nail down a ballpark figure of what this would cost. And even CBO, who has been known from time to time to guess and predict and sometimes guess incorrectly even, won't even hazard a guess of what this bill costs. In fact, what they tell us in the letter is that they know it's going to cost something. They have no idea how much. And why? Because you can't predict the future. But you can predict one thing, and that is Congress will respond. To just fully indemnify and to throw in this blanket blank check into this bill without recognizing the perspective and the understanding of where we've been this year would be, I believe, irresponsible. Let's just review this year.
Mr. Chairman, at this time it's my pleasure to yield 3 minutes to the distinguished whip, the gentleman from Texas, Mr. DeLitt.
The distinguished majority whip is recognized.
Let me first, Mr. Chairman, say that those that are on the cutting edge of technology and wanting to provide it are protected in the base text of the bill by limiting their liability and banning punitive damages like we've done in the Transportation Safety Administration and other instances. But, Mr. Chairman, there is an unacceptable demand that America needs to know about right now. Some of the largest and most profitable corporations in the country are attempting to pass off legal liability for their products onto average Americans. These defense contractors are trying to feed the tax-paying public to the crocodiles of the plaintiff's bar. American taxpayers shouldn't be asked to absorb the devastating financial consequences that would flow from creating an enormous new unfunded liability. Taxpayers shouldn't be footing the bill for a gigantic new windfall for trial lawyers. Even now, the plaintiff's bar is eagerly anticipating new ways to exploit the new terrorist attack through litigation against the companies that are developing terror-fighting tools. And what's even more outrageous is that multi-billion-dollar defense contractors have the nerve to come to Congress, hat in hand, to demand that taxpayers foot this bill. If these defense contractors bear the responsibility for the failure of their technology, then they should be held responsible. And if these contractors are being unfairly sued, they should be penalized only because they contributed to the anti-terrorism effort in this country. Then these lawsuits need to be stopped. And that's exactly what our base text ensures. We defang frivolous lawsuits that do nothing but line the pockets of trial lawyers. What we need is broad-based litigation reform. What we don't need are multi-billion-dollar defense contractors making American taxpayers responsible for the quality of their technology. This would truly be a case of corporate welfare. It's ironic that members of the minority who routinely malign Republicans as the party of corporate America are so willing to subject taxpayers to a bottomless pit of unfunded liability to protect these corporations. Clearly, supporters of this amendment place a far greater weight on the wishes of their trial lawyer friends than they do to the dangers created for fiscal discipline and the American taxpayers. And I ask that you vote no on the Turner Amendment.
Gentleman from Texas, Mr. Turner.
Mr. Speaker, this time, and I'm proud to yield 3 minutes to the distinguished gentleman from Oklahoma, the conference chairman and a member of the select committee, Mr. Watts.
Mr. Watts is recognized for 3 minutes.
Thank you, Mr. Speaker, and I thank the chairman for yielding. Mr. Speaker, the Turner Amendment is fiscally irresponsible because it hands over the keys of the United States Treasury to trial lawyers. It would have the American taxpayer, not corporations, but American taxpayers pay nearly infinite damages caused by terrorists. We need the Safety Act provisions to ensure that Americans get the protection they deserve against future terrorists. The fatally flawed tort system in America and the unbounded threat of liability of blocking the deployment of anti-terrorism technologies that could protect the American people. And I want to give you one illustration of where this really comes into play and just give you some idea of the lack of common sense that the Turner Amendment would tear down. And you might have heard this illustration today, but I still want to point it out to you again. The insidious dynamic that prevails under current law works as follows. A company might produce a smallpox detection device and deploy 100 of them. Terrorists strike. 99 of the devices might work, saving millions of lives. One device might not work, and several thousand people might die. Lawsuits will follow. The potentially infinite liability to which the lawsuits currently expose the company will prevent the company from being able to deploy any of the 100 smallpox detection devices in the first place. The 99 that worked will be pulled off the market, which, if that happens, it would destroy, it would put thousands and thousands, millions of Americans, it would expose them. That's the tragic consequence the Safety Act is designed to prevent. The Safety Act provisions place reasonable and sensible limits on lawsuits so that America's leading technology companies will be able to deploy solutions to defeat terrorists. And what the Turner Amendment does, it actually takes the liability away or takes the safety features away from the people that go to the malls, that go to the stadiums, the water treatment facilities. They all won't be able to have access to these technologies that protect us, that protect our kids, that protect our families, that protects this nation. It just makes no sense. It's time for Congress to stand up to the trial lawyers yet again and say no, especially now that we are at war against terrorists who will stop at nothing to harm innocent Americans. We saw it on September 11th. We saw it on April 19th in 1995 in Oklahoma City. This is about protecting American life. It's not about limitless lawsuits. Vote no on the Turner Amendment. I yield back the balance of my time.
Gentleman yields back his time. The gentleman from Texas.
And at this time, I'd like to yield 3 minutes to the gentlelady from Ohio, the member of the committee and the distinguished jurist in this body.
The gentlelady from Ohio is recognized for 3 minutes.
I appreciate those kind words and thank the majority leader and the author of...
Mr. Chairman, at this time I yield 1 minute to the distinguished gentleman from Virginia, Mr. Davis.
Gentleman from Virginia is recognized for 1 minute.
Ask unanimous consent to revise and extend.
Without objection, so ordered.
A lot to say. Let me just say that the
Majority Leader.
Mr. Speaker, I have one other speaker on the way. He's not yet arrived. If I do expect to close the debate, so I would suggest perhaps the gentleman from Texas might have another speaker and see if my other speaker arrives. If the gentleman would go ahead.
Majority Leader reserves his time. Gentleman from Texas.
Pleasure at this time to yield 3 minutes to the distinguished attorney and member of this body, Mr. Goodlatte from Virginia.
The gentleman from Virginia is recognized for 3 minutes.
Mr. Chairman, I yield myself such time as remains. Mr.
Gentleman
Chairman,
is recognized.
we have heard a great deal about the bipartisan support of this amendment. Irony of ironies, where there is bipartisan support, there can be bipartisan rejection. Let me say, Mr. Chairman, this amendment had an interesting experience in the Committee of Jurisdiction, one of the 12 standing committees that worked on this bill. When it was proposed on the eve of the night markup of this bill in that committee, it was proposed and opposed by the ranking Democrat on the committee, Mr. Waxman, who said, and I quote, "It really is opening up the Treasury of the United States to a lot of companies that might have exercised due care. And more importantly, when companies are indemnified, even if they are negligent, there is not the incentive to avoid being negligent." This approach to the problem was contemplated in the other body, and indeed, in this case, the ranking minority member, a Republican member in the other body, had intended to offer this amendment in the other body's markup just yesterday and was dissuaded from doing so by the majority members, the Democrats of the committee, who thought it imposed too big a burden on the Treasury of the United States. Mr. Chairman, I'm not a lawyer, so I have to rely on other legal experts, like, for example, the Supreme Court. In this debate, it has been argued that when a government contractor has a defense, it is an immunity. I only point out that to the minority that the Supreme Court has said a defense is not an immunity. This is always going back to the legal questions that baffle us so, such as what the meaning of the word is. But in this case, the meaning of the word defense is not immunity. Let me say, Mr. Chairman, that what we are trying to do was well described in several people. We are trying to encourage that practical American genius to bring its product to the defense of America. What this base language that would be set aside by this amendment does do is provide a consolidation of claims in federal court to stop venue shopping. It has the requirement that non-economic damages be awarded only in proportion to a party's percentage of fault. It has a ban on punitive damage. It takes this sort of simple, practical American notion that if you are a victim, you should not be treated as if you were a perpetrator. A rather novel idea, I'm sure, in some circles, but quite well understood by most Americans. The underlying language says offsets are awarded based on the receipt of collateral source benefits, provided compensation for the same injuries, no double dipping. This is something that I have in other contexts referred to as the Daschle provision, having been enacted in law pursuant to the innovation of the distinguished Democrat majority leader in the other body. The underlying language has a defense modeled on government contractors' defense that applies following sales of qualified anti-terrorism technologies in the private sector, and it caps liability and insurance. This has been enacted in this body before. This is not some Johnny-come-lately notion new to this body. It was part of the Aviation Security Act. It was part of the Air Stabilization Act. It was part of the Terrorism Risk Insurance Bill, and it was part of the Class Action Reform Bill, passed in this body in this year. What we don't do in the underlying language that would be set aside by this amendment is put a cap on attorneys' fees, provide any immunity for anybody, anywhere, at any time, or exempt criminals from coverage. Mr. Chairman, I don't ask much, but I do ask for accuracy in debate. There's been far too little of it. I ask the body reject this amendment and uphold the underlying language.
Time of the gentleman has expired. The question is on the amendment offered by the gentleman from Texas, Mr. Turner. As many as are in favor will signify by saying aye. Those opposed will say no. The opinion of the chair, the noes have it.
Mr. Speaker.
Gentleman from Texas.
Request a record vote on the grounds that quorum is not present.
The chair will count for a quorum. Does the gentleman withdraw his point of order?
Yes.
Those in favor of recorded vote will stand and be counted. Sufficient number having arisen, a recorded vote is ordered. Those in favor of the amendment will vote aye. Those opposed will vote no. Members record their votes by electronic device. Pursuant to Clause 6 of Rule 18, following this 15-minute vote, the chair will reduce to 5 minutes the time for the vote if ordered on Amendment 20 by Mr. Waxman, Amendment 21 by Mr. Army. This will be a 15-minute vote followed by 2 5-minute votes. The yeas are 214, the nays are 215. The amendment is not agreed to. Pursuant to Clause 6 of Rule 18, the chair announces that he will reduce to a minimum of 5 minutes the period of time